Performance rights is a protection of the exclusive rights in regards to their performance that are separated from a copyright work. Previously, performers did not enjoy any copyright protection even though such forms of expression were arguably no less artistic and creative than the copyright work. Not to mention, the effort and the time exerted into perfecting their performances could possibly add value to the copyright work. The importance of performance right emerged as technology advances. Prior to 20th century, there was no recording technology that allows a performance to be reproduced. Yet, with nowadays technologies, good quality bootleg recordings of performance could be easily reproduced without performance consent, which will expose the performances to commercial exploitation. Although the history of copyright law could be traced all the way back to 1969, the addition of performance right was only done recently in year 2000 to comply with the Malaysian obligation under the Agreement to Trade-Related Aspect of Intellectual Property Rights. Under the amendments in year 2000, the performance right was granted to the performers. The amendment provides the performers with the exclusive rights to control and prevent the doing of certain acts in regards to their performance before their consent is given. Moreover, the amendments also enables performers to receive better protection for their exclusive right in respect of equitable remuneration. The right of the performers has subsequently been strengthened in the revision that took place in year 2012, which was influenced by WIPO Performance and Phonograms Treaty 1996. Under Article 5(1) of the treaty, a performer shall be entitled to moral rights in their live oral performance or performances fixed in phonogram, and this was then adopted in Malaysia through the 2012 amendment. The introduction of performance moral rights was said to be a major innovation in moral rights doctrine because it elevates the performers from someone who merely disseminates the author's work to a legal status equivalent to the author himself. For an entity to be entitled to performance rights, the performer and his performance must have fall into the scope of definition encompassed in Section 3 and qualify under the criteria under Section 10A of the Copyright Act 1987. The general definition in Section 3 covers almost all types of performance and performances which the public usually encounters, except for several acts that are excluded for non-essentially concerned with the performing arts, such as any reading, recital, or delivery of any items of news or information. Besides, an act can be considered as a performance even without an audience, as long as it was performed live by the person. Hence, it can be seen that performance right is widely available to all performers in Malaysia, but it would defeat the purpose if the protection provided is ineffective. Therefore, in the subsequent presentation, my teammates will be discussing the significance of performance rights and whether or not it is effective in protecting them. I will now pass on to Danusha, who is going to present on the significance of performance rights.
Thank you, John. So what is the significance of recognizing performance rights? As mentioned, performance rights was only added in 2000 to comply with TRIPS, the Agreement to Trade-Related Aspect of Intellectual Property Rights. The significance of complying with TRIPS through legislation identified by Dr. Kaur Leiti is that number one, it establishes minimum standards and principles concerning the availability, scope, and use of intellectual property rights as well as the enforcement. Secondly, each member is required to accord the nationals of other members the same treatment that it accords to its own nationals with regard to the protection of IP through Article 3. This is known as the principle of national treatment, which ensures that nationals of member countries are not discriminated against other members. Thirdly, TRIPS requires members to accord the most favoured nation treatment to all members following Article 4. Any advantage, favour, privilege or immunity granted by a party to a national of any other country shall be accorded to all other parties. The principle of national treatment ensures that nationals of convention countries are not discriminated against in other convention countries. It does not, however, ensure that the same level of protection as found in one convention country is granted in another. Although Malaysia is not a contracting party of the WIPO, Performances and Phonograms Treaty 1996 WPPT, the country's regime on the protection of performance under the Act has been influenced by this treaty. More specifically, Article 5, Subsection 1 of the WPPT, which provides that performers must be given moral rights of their live oral performances or performances fixed in phonograms, has been adopted in Section 25A of the Copyright Act 1987. Section 25A confers to moral rights on the performer which correspond with the moral rights of authors of copyright works. A performer enjoys two types of moral rights. First, he has the right of attribution, which is the right to be identified as the performer of his performance. Secondly, he has the right of integrity, which is the right to object to any other distortion, mutilation, or other modification of his performance that would be prejudicial to his reputation. Such moral rights subsist even after the death of the performer, and pursuant to Section 25A, Subsection 2, each shall be exercisable by persons of institutions authorized by the performer. Unlike moral rights of authors of copyright works which are expressed in Section 25, as a prohibition on the doing on certain acts by others, the moral rights of performance are expressed in positive terms. Lastly, on equitable remuneration, what amounts to equitable remuneration or its calculation is not provided in the CA 1987. However, it would appear that the quantum of the remuneration would depend on the work that is used, the economic importance of the work to the licensee, and the royalty collected. Prior to the Copyright Amendment Act 2012, once a performer gives his consent to the fixation of his performance with the consequence that he loses his exclusive right, spelled out in Section 16A, Subsection 1, he is nevertheless given the right to receive equitable remuneration for a number of specific uses of sound recordings that have been made of his performance. Pursuant to the new Section 16A, Subsection 2, a performer's exclusive right continues to subsist even after the performer has given his consent to the fixation of his performance, and Section 16B, Subsection 1 continues to confer upon the performer the right to enjoy equitable remuneration for the specific uses of the sound recording mentioned in that subsection. The right of a performer to receive equitable remuneration is not the result of his exercise of any of his exclusive right, but is the consequence of certain uses of a sound recording made of his performance. In the absence of a contract between the performer and the user of a sound recording with regard to equitable remuneration payable, the new Section 16B, Subsection 3A, which was inserted by the Copyright Amendment Act 2012, allows the performer to apply to the Copyright Tribunal to determine the amount payable as equitable remuneration. Therefore, it can be seen that there are significant changes in the performers protecting their copyright. Thank you. I would now like to pass it on to Gideon.
Thank you, Danusha. Now I will explain the effectiveness of copyright protection for performers in Malaysia. This is measured by the extent of copyright protection available for performers, as well as punishing offenders for infringement. This statutory right to a performer is defined in Section 16 of the Copyright Act in 5 areas to constructively control. Firstly, communication to the public of a performance. Section 3 defines communication to the public as the transmission of a performance through wire or wireless means to the public. This includes cable, terrestrial, satellite, and digital and internet transmissions. While traditionally this right was not available where the performance is a live broadcast, recently, however, in Sheikh Abdullah bin Ahmad against Universal Music, the court recognized that Section 16(1)(a) is limited not only to live performances but to recordings in studios as well. Secondly, a performer has the right to control the fixation of an unfixed performance. In other words, this means the right to control the recording of performance from a live broadcast. This can be in the form of a sound recording, film, or other audio-visual recording. In the event that an illegal fixation is carried out, such as bootlegging, the performer nevertheless retains the right of first fixation, since he has not given his consent to anyone of the fixation of his performance. Next, the performer has the right pursuant to Section 16(a)(1)(c) to control the reproduction of the fixation of his performance. Previously, this was limited to specific situations only. However, the 2012 amendment has removed restrictions such as the making of a transient copy of the fixed performance. Fourthly, Section 16A(1)(b) corresponds to the distribution right of a copyright owner under Section 13(1)(e). The performer is entitled to control its distribution to the public, the fixation of a performance and its copies thereof through sale or other transfer of ownership. In the same case of Sheikh Abdullah, the Intellectual Property Court of Malaysia further extended the right of distribution by the performer beyond the first distribution to subsequent distributions. Finally, the right provided under Section 16A(1)(e) allows the performer to control the commercial rental to the public of copies of his performance, irrespective of the ownership of the copy rented. The nature of the rental is such that the original copy will bring returns of direct or indirect economic or commercial advantage to the performer himself. Nonetheless, these statutory provisions will be pointless if it cannot be enforced by the Copyrights Act 1987. Hence, Section 39A effectively grants claimants the right to sue offenders who breach their performance rights set out under Section 16. It applies the concept of mutatis mutandis to performers and entitles them to invoke Section 36 for the offense of infringement. It states that a person who infringes the exclusive right of a performer when he does an act mentioned above without a license granted by the performer. As such, by reason of Section 39A, a suit for infringement of performer's right may be instituted under Section 36(1). By deliberately omitting equitable remuneration right in Section 39, Parliament has intended by way of Act A 1082 that no infringement action under Section 36 can be commenced in respect of equitable remuneration right. This shows another distinction under the Copyrights Act between performer's right and equitable remuneration right. Section 36(2) further provides that it is an infringement to import an article into Malaysia for commercial purposes where he knows or ought to reasonably know that the making of the article was carried out without the consent or license of the performer. Finally, Section 37 provides the remedies available to performers when their right has been breached. This list of remedies include damages, injunctions, and accounts or otherwise in respect of infringement or other proprietary rights. Thank you. I will now pass the time to Yan.
Thank you, Gideon. Despite providing effective protection to performers with regards to copyright protection under the amended Copyright Act 1987, there are areas that need amendments for better protection to the performers. Section 16B further provides the right to collect an equitable remuneration when the sound recording is published for commercial purposes or being performed publicly or used directly for broadcast or other communication to the public. Unfortunately, an actor's right to equitable remuneration was not provided under the Copyright Act 1987, even though WPPT deals with performers in general, but the economic remuneration granted is only for phonograms and not audiovisual works. So, what are phonograms? In light of Section 25A subsection 3 of the Copyright Act, phonogram means the fixation of the sounds of a performance or of other sounds or of a representation of the sounds, other than in the form of a fixation incorporated in a film or other audiovisual work. Audiovisual work is not defined anywhere under this Act, but under Section 43A subsection 3, audiovisual recording device means any device which is capable of recording or transmitting a motion picture or any part thereof. Motion means film. Deriving from this definition, it means only the sounds from a performance can be entitled to copyright protection, but not the performance in a form of motion. This implies that an actor, as opposed to a singer, could not collect equitable remuneration for the playing of his or her performance. These provisions illustrate that the copyright law vests strong rights to the authors, producers, and broadcasters. These are the three original parties addressed in the Rome Convention whilst performers are given lesser right in the treaty. With the 2012 amendment, the rights of the performers have been strengthened. Not only performers are given strong exclusive rights, but also moral rights. However, with respect to the right to extract royalty payment for the broadcast of their performance, this is only applicable to sound recording and not audiovisual work. This means actors involved in the production of films and teledramas do not have the right to collect residual payment for the airing of their performance on broadcast or other method of performance in the public. In addition, the usage of the word equitable remuneration and not royalty gives the impression that the performer's right is subsidiary to the other three groups of the right holders. In addition, the estimation of the amount of equitable remuneration is not clarified under Section 16b, and it is stated under Section 16b subsection 3a, in absence of a contract on equitable remuneration, the performer may apply to the tribunal for the determination of the amount payable. In the case of Prism, Berhad and Miasat Broadcast Network System 2017, the court held that there is no contract between the performers and the defendant regarding equitable remuneration for the defendant's use, unless and until the tribunal has decided on the quantum of equitable remuneration payable by the defendant under Section 16b subsection 3a. Performers have no right under that section to claim for such an equitable remuneration. The amount of remuneration appears to depend on the utilization of works, the economic significance of the work for the licensee, and the royalties received. Since it's a discretionary issue, it will be detrimental to the performers if the remuneration is not satisfactory, even though the performers apply for variation of previous determination of the tribunal's decision relating to amount payable. So, what are the options for Malaysia? If Malaysia is serious in guarding the interests of the actors, one option is to consider being a signatory to the Beijing Treaty on Audiovisual Performance 2012. The treaty, which came into force on 28 April 2020, contained provisions that enable countries to confer audiovisual performers the right to collect remuneration for making available to the public broadcasting in combination to the public of their audiovisual performance. Since its entry into force, over 41 countries have enforced and adopted the treaties into their legal systems. The objective of the treaty is to secure audiovisual performers the ability to obtain a fair share value of the rebroadcasting and the airing of the films that they have participated in. For instance, Section 78 of the German law on copyright and neighbouring rights acknowledges the performer's rights to collect an equitable remuneration for the communication to the public of an audiovisual performance. In those countries, there exist licensing bodies in charge of the collection of actors' royalties. Therefore, Malaysia may consider being a contracting party to the Beijing Treaty. So now, let's move on to the conclusion.
In conclusion, the addition of Performance Right in Copyright Act 1987 has given Malaysian performers a greater protection in terms of their exclusive rights, access to equitable remuneration, and moral rights. As established above, the strongest protection of performance right is encompassed in Section 16A, where most performers are given huge range of exclusive rights to control the doing of certain acts in regards to their performance before their consent is given. However, from what we are stating above, it can still be seen that doctrine of performance right is lacking when it comes to equitable remuneration, as the rights of equitable remuneration is only available to sound recordings. Not to mention the amount of equitable remuneration granted by the tribunal is final even if the amount is unsatisfactory. Hence, this has highly diminished the effectiveness of protection towards performers' copyright. With that said, the current performance rights encompasses under Copyright Act 1987 is yet to be fully effective in protecting performers' copyright, and it is important to ensure the protection over performance right is effective so that the performers can be protected and rewarded for the effort expended in the performance, encouraging them to contribute further in the creative industry. Thank you.